Hello, everyone. This is Aaron Gelb from Conmuscular Carry. I'd like to welcome you to our July 13th webinar. We are going to get started now with our webinar, Marijuana Drug Testing and Background Checks. I am a partner in the firm's Chicago office, and I'm being joined by my colleagues, Dan Deacon and Ashley Mitchell. So what we wanted to do today, we put together this program for you all to cover a host of different issues that all kind of, I think, share a common theme or thread, if you will, of issues that you deal with both during obviously the hiring and onboarding process, making decisions about who to bring on board, as well as obviously who to retain if things come up during the course of their employment that deal with kind of an updated or ongoing background check or drug testing results. And these are a series of laws, certainly if you operate in multiple jurisdictions, different states across the country, or even just a single state, that the law is changing rapidly as we see kind of more and more states take an interest in these sorts of privacy issues, compliance issues, that states are then responding with protections for employees with criminal background, expanding the ability to use marijuana both for personal use as well as medical reasons. So it's a lot for employers to juggle. You've got kind of there's an overlay of federal laws in certain areas, but federal law doesn't cover every aspect or all of these issues. So then you have the states that are filling in, as well as even in some instances counties or cities. So it's this patchwork of laws and regulations that can be quite difficult for employers to track. So what we wanted to do really is kind of give you some overarching advice and provide really a framework so to help everyone kind of understand and how to approach these issues. So we're going to start, and I'm going to talk a little bit about the federal and state laws that cover work-related drug and alcohol testing. Then we'll get into the restrictions that Osha has placed on drug testing through its injury reporting and anti-retaliation rule and how that's changed over the years. We're also going to talk about Americans with Disabilities Act issues, the ADA, and how that applies to drug testing and such issues. We'll then cover background checks and the Fair Credit Reporting Act. That's an area that we find time and time again that many employers struggle with. All right. The first subject we're going to talk about is the kind of the intersection between drug testing and employment law as kind of I think important to set the stage and really understand kind of how the law works in this area. The background, if you will, which I'll talk about on the next slide. There is no comprehensive federal law regulating drug testing in the private sector. For those of you that are familiar, and we're going to cover that in a second, the Drug-Free Workplace Act that covers drug testing, but in terms of if you're looking for a universal overarching kind of guide or set of authorities with respect to drug testing, it's not found in the federal system. So what Uncle Sam does say, moving on to the next slide, the Drug-Free Workplace Act, your employers are not required to conduct drug testing under that law. For those that are covered, federal contractors and others, you do have to develop and implement a drug-free workplace policy and a program. If you're covered either by certain Department of Defense regulations, or if you're a DOT covered employer, so those of you all with certain that have delivery trucks or other types of vehicles that are large enough that fall under DOT regulations, then there is a whole series of drug testing rules and regulations that you do have to comply with. But if you have your operations that are not DOT covered, or if you're not covered in any way by the DOT or the DOD regulations, while you may be required to have a drug-free workplace policy, there would be no other testing requirements that are imposed by federal law. What further complicates things, as I assume most of you all know, is that marijuana is still listed as a Schedule I drug under the Federal Controlled Substances Act, which is why we find ourselves still in this somewhat interesting situation where it's illegal under federal law, but all the states are kind of getting out ahead of the federal system and passing laws that allow either medical use and or personal use of cannabis or marijuana. So we have situations where there are a limited number of options as far as payment collections and banking and things like that for those companies that are selling these products. So at some point, I think it could be sooner rather than later. It remains to be seen if it'll happen during the Biden administration, but I certainly think that the tide is moving in such a direction that at some point we probably will see marijuana or cannabis legalized in some form or capacity. But until that happens, again, it is still a Schedule I controlled substance, which has implications, as we'll talk about a little bit later, with respect to laws like the federal laws like the Americans with Disabilities Act. So then moving on to the next slide, as far as if you do have DOT covered operations, marijuana, as I said, its use is still prohibited. So even if you are operating in a state, as I said earlier, I'm here in Chicago, Illinois, where a couple years back, the state legalized personal use or recreational use of marijuana. That state law obviously does not supersede or take precedence over the federal law. So if you have operations in Illinois or any other state that has legalized cannabis or marijuana, whether it's for recreational or medical use, and you are a DOT covered employer, the marijuana use is still prohibited for those employees that are holding those covered positions. So if you are covered by these regulations, hopefully you have a robust testing program and policies in place. But just as a refresher, testing is required pre-employment, in the event of an accident, testing is required. Random testing is required, reasonable suspicion, and then if somebody does test positive and they are out and able to return to work, then there are requirements with respect to return to duty and follow-up testing. When you are hiring individuals for DOT covered position, you have to obtain drug and alcohol testing information from their prior employer over the past 2 years. And then there is also regulations with respect to alcohol and other drug testing, how it's conducted, when it's conducted, et cetera. So this is the laws and the regulations with respect to DOT testing are very complex, very complicated. There's a lot of work that goes into them. So if you're not sure whether you're covered, if you're not sure whether your system is compliant, obviously feel free to reach out to any of us. We can walk you through that. In some cases, we'll work with consultants who can help you design and develop and implement those programs for you. Moving on to the next slide. So once you kind of put aside this federal system or as I said before, the lack of kind of an overarching drug testing law or any regulations with respect to employers in general outside of the DOT realm, the main takeaway is that, and again, this is particularly applicable for employers in multiple jurisdictions, is that there is no one way to conduct or ramp up a drug testing program. Each state does it differently, and in some cases, very differently. One of the things that I find particularly interesting is that the laws with respect to drug testing, drug and alcohol testing, do not kind of track the expectations that you might have with respect to a state being kind of pro-employee, such as California, or a state that you might expect to be kind of more pro-employer based on regulations or the lack of regulations. And I think in large part that is due to the privacy aspect to this. So there are some states where you might expect the laws to be very pro-employer, meaning that employers can conduct any sort of testing at any point, at any time, in any method, when in case that may not be the situation. So really the upshot is if you are expanding operations into a new location, or if you're simply not sure whether your current testing regime is fully compliant, it's important to take a deep dive and do the research into the state or states in which you have your operations to make sure that you're conducting your testing in an appropriate and legally compliant way. Some of the issues that we see come up from time to time is that there are a number of states that either do not allow or limit random testing. You can see how that might be consistent with that privacy concern. You're more likely to be allowed to do reasonable suspicion, probable cause, post-accident, post-incident testing. That's an easily justifiable type of testing. But when you're doing random testing, you're basically an employee who's done nothing to suggest that they are using drugs. Then there are a number of states that restrict that. There are restrictions or regulations with respect to how the testing is done, with respect to the handling of specimens and test results. There are states that limit pre-employment testing, and too many rules, regulations, and requirements to kind of cover really in any one webinar or program because there is such a large number of them. So again, the key is to really making sure you're familiar with the regulations in your state and any states in which you operate or maybe considering operating. Moving on to the next slide then. There are a number of other legal concerns, ones that may not immediately jump to mind, but it's important to consider. For example, discrimination. This is something when you see, and we're going to talk a little bit about in a few minutes, on the Osha side, there are recommendations that Osha has with respect to not conducting blanket testing. I think Dan is going to talk about that in a little bit. And using discretion. Well, when you invest your discretion in your managers and you give them the ability to select people for testing, what does that have the potential? That is the potential to create a discrimination claim. If you say, well, we test everybody in this circumstance, regardless of what happened, that's one way to avoid or head off a discrimination claim, because somebody can't claim that they were singled out due to their race, their sex, their age, or ethnic background, or whatever the reason. But then you might run into concerns from the Osha side, as Dan will talk about. So if that's one area that you want to take a look at, is make sure that your managers are trained, make sure that they have written guidelines, whether it's an SOP or some sort of procedures, so they know when to send someone for a test, what criteria to look at. Ideally, you'd have forms or documentation for them to use to track and record why they're sending that person for a test. As far as how the testing is done, if it's done on site, there's the potential for an invasion of privacy claim if the person doesn't have adequate privacy to provide, for example, provide a urine sample. There's also the potential for a defamation claim. Say you terminated someone because of a positive test result. Just like any employment related determination, whether it's a separation for any reason, you have to be mindful of who you share that information with. Do they have a need to know that information? So obviously sharing that information with the person's supervisor, other key members of management, that's generally going to be okay. But this is why one of the main reasons employers don't share this sort of information with coworkers, with hourly employees, with third parties. When you open that door, then you're opening the door to a potential defamation claim. You also need to consider, if you are looking at adopting a drug testing program, making changes to your drug testing program, do you have a union? That is generally going to be a mandatory subject of bargaining if you are going to be adopting such a program or making material changes to their program. At the same time, if you are not unionized, but you're concerned about organizing, the adoption of a drug testing program, depending on your workforce, the location, the type of work, the type of employees that you have, That's the sort of thing that could jumpstart an organizing campaign. So from a practical consideration, you need to think about the implications of adopting a drug testing program if you don't already have one, or covering a new set of programs, or I should say new set of employees, or a section of your workforce that previously was not subject to testing. So that is, in a nutshell, a brief overview of the considerations, the things that you need to think about with respect to the development of a drug testing program, drug and alcohol testing, I should say. So I'm going to hand it off to Dan, who will introduce himself and then talk about the OSHA's rule on the tracking of workplace injuries and illnesses and how that impacts drug testing in the workplace.
Thanks, Aaron. This is Dan Deacon here, and I'm going to talk about OSHA's e-record keeping rule. And interestingly enough, this was a rule designed to require employers to submit injury and illness record keeping data to OSHA on an annual basis. But in the preamble to the final rule, the hundreds and hundreds of pages that explain and justify why the rule is being issued, they snuck in these anti-retaliation provisions, one of them being related to post-incident drug testing. So when we talk about the federal government not necessarily having an overarching drug testing law, there is this one unique caveat to that, and that's OSHA's e-record keeping anti-retaliation provision and what it says about drug testing. So OSHA's position is that drug testing could dissuade a reasonable employee from reporting a work-related injury because of those privacy issues Aaron was referencing throughout the first couple of slides there. It made clear in the preamble that post-injury drug testing is not to be used as a form of discipline, and that rule and that train of thought still applies today. And the one blanket rule that came out of this was that blanket post-injury drug testing policies are strictly prohibited. So if you still have a policy that requires employees that are involved in an incident to go get a drug test, no matter what the circumstances following that incident, OSHA will take a hard look at that and likely find that to be problematic. You might be answering some questions about how you implement that policy, and really it's the implementation piece that's important, right? So the rule itself only pertains to post-incident drug testing. So OSHA's rule does not affect any of the following drug tests that you see on the screen here. Pre-employment testing, random testing, if you need to conduct post-incident testing to comply with state or federal law requirements. For example, the DOT mandatory post-accident test requirements, those trump OSHA's rule. There's a carve-out exception there, right? If you need to conduct a post-incident drug test to comply with the state or federal law, that's fine. That's still permissible. You can continue doing that. And there are some states that do have that. The other carve-out here is for workers' compensation insurance. If you are required by a workers' compensation carrier to conduct post-incident drug testing as a part of your program to receive a premium reduction, you may continue to do so, and those mandatory post-incident drug testing policies are permissible. And then the key language is at the bottom of the screen here. Post-accident or post-incident drug testing is permissible when drugs or alcohol likely contributed to the injury and where the test can ID present impairment. So the able to identify present impairment piece, that was immediately raised as problematic and an issue for every single type of employer, right? Because you can identify present impairment for alcohol, but as of right now, and back in 2016 when this rule was implemented, there was no way, and there still is no way, to identify present impairment for other drugs, marijuana, cocaine, etc. So that's why, if you do have one of these incidents and you're considering doing a post-incident drug test, we also recommend making sure that you're going through your reasonable suspicion analysis as well. So doing those side by side. So the last slide here is the most recent update that OSHA has provided on its post-incident drug testing policy. And there was a lot of debate over the years since 2016 about how this rule should be implemented, what's required. and what employers are supposed to do. So, of course, you should take a close look at your policy and make sure that you don't have a blanket post-incident drug testing policy. There needs to be some of that discretion and an evaluation of the facts and circumstances of each incident. But OSHA did soften its position on the drug testing piece, as well as the safety incentive program elements of the anti-retaliation rules. And as it relates specifically to post-incident drug testing, they said it may be used as a tool to evaluate the root cause of a workplace incident that harmed or could have harmed employees. And the key message that OSHA conveyed in this memo was that, again, it's not intended to be used as a form of discipline. So if you have several employees, for example, that are involved in an incident and you're unsure how the incident happened and you're looking for that root cause and want to find out if drugs or alcohol may have contributed to that incident, you are certainly within your right to do so. And you should make sure that all of the employees that were involved in that incident are drug tested, not just the employee that was injured. So with that, I'll turn it over to Ashley, I believe.
Yep, thanks, Dan. Good afternoon, everyone. As Dan mentioned, my name is Ashley, and I'm an associate in the Chicago office. And now I'm going to be talking about the Americans with Disabilities Act as it relates to background testing as well as background checks as well as drug testing laws. And so on the next slide, we are here to talk about the ADA, which protects disabled individuals from discrimination if they are qualified to do the job. And so drug testing is allowed under the ADA because the ADA generally does not consider drug use a disability. And the exception to this is the limited case of addiction, which may be considered a disability in some cases. And so in particular, for those who have recently recovered from drug or alcohol addiction, they may be protected if that employee or applicant is now qualified for the position and is no longer abusing drugs or alcohol. An employer should be aware of this limited exception. But this protection does not extend to those who are currently using or abusing drugs in a way that is against company policy. It is important to note here, and it'll come up again later in our presentation, that the primary reason many organizations require drug testing is to keep the workplace safe. And it can be argued that employers have an obligation to ensure that their workplace remains drug-free in order to create a safe environment for all of their employees. So this, in essence, creates a legal liability for employers who haven't taken steps, including drug testing, to keep impaired and individuals off the premises, especially individuals in safety-sensitive roles. And so this is also the primary reason that drug tests are considered legal, because that obligation to keep a safe working environment trumps an individual's privacy right in the eyes of the law. And so on the next slide, we look at disability discrimination. And so just because drug testing in and of itself does not violate the Americans with Disabilities Act, employers must ensure that their drug testing policies do not have a disparate impact. For example, if applicants of a certain race or national origin are tested as a condition of employment, but others applying for the same position are not, then that would be a discriminatory application of an otherwise legal drug testing policy. And so in short, it's legal to test across the board as a condition of employment for a certain position, but it's not legal to only test select individuals for the same position. A little caveat to this, it is legal to require drug testing for some positions and not others. So, such as those positions that have a safety concern. So as long as the testing is happening based on the position itself and not the individual, that particular testing would not violate disability discrimination policies. It is also important, as we talk about disability discrimination, to think about disparate impact. Since some disabilities do require medication, this medication may show up in drug test results. If the positive result on the test is from a prescription medication, assuming that that medication is being taken in a way that's consistent with how it's being legally prescribed, then it may be discriminatory to hold that against the job applicant or the employee. So employers should be sure to know when the exceptions due to disability are appropriate. And so in sum, drug testing is generally permissible under the ADA, but employers should ensure that their policies are neutral on their face as well as their application. Important to our disability discussion is the conversation around reasonable accommodation, because the reasonable accommodation standard applies throughout all parts of the employment process, including the application, hiring, and employment or duration of employment timeframe. And the reasonable accommodation standard requires employers to make reasonable accommodations to allow individuals with disabilities to apply and be considered for jobs, so long as that accommodation does not cause undue hardship. And so as we think about drug testing, this includes accommodations in connection with pre-employment drug testing. And I believe I am turning it over now to Aaron.
Yes, thanks, Ashley. And just to follow up on that last point, for example, there have been cases where an individual is unable to produce a urine sample, either due to, I've heard it referred to as shy bladder syndrome, or in some cases due to a kidney, poorly functioning kidneys or other reasons, in which case you may well need to look into some sort of accommodation. It doesn't mean that they don't have to take the test, but it may be that the test is conducted in a different manner or by a different method. And I think one area where we see employers, or a couple of ways that employers can get into trouble in this regard. One would be your line managers, the folks that are managing the application or recruitment process at your local sites, are not aware of this. They haven't been trained, and they kind of summarily reject that applicant and don't alert human resources or don't alert corporate as to this issue. They think that they can simply reject that person, not because they have an intent to discriminate, but they don't understand the policy. So educating them about issues like this, so they at least know that they should alert somebody as to that issue. So somebody who is familiar with employment law, with the ADA, can weigh in and assist. And the other is having kind of a broader across the board inflexible policy. As Ashley talked about disparate impact, it could, those are the sorts of barriers to hiring or entry that the EEOC tends to focus on as part of its strategic enforcement plan every few years. So if you have a hiring or recruiting policy that does not allow for exceptions or modifications based on someone's disability, that again is something that could be a problem for you, and so you'd want to take a look at. So with respect to the marijuana laws, and I referenced this, if you look on this slide, I referenced this at the beginning. This is one area where the law is changing very rapidly. I think it's almost every month or so. We go back and check to see if any new states have been added to the list that you see on this page, and we're going to show you in a second on the next. I think Dan and I recently presented a webinar in New Mexico because that state is in the process of legalizing the recreational use of marijuana, and not surprisingly. The changes have initially been seen primarily on the medical medicinal marijuana use. So as you can see here on the slide, 37 states and the District of Columbia have legalized the use of medical marijuana for various conditions. Well, what you tend to see in this area is the number of covered conditions expand, the access or the ability of employees to obtain cards that authorize them to use medicinal marijuana become more readily available. So what the upshot obviously is that I think generally more and more employees, certainly in those states where perhaps there is not recreational use allowed, are accessing and using marijuana under the auspices of a medical marijuana card. So as you can see here, with almost 80% of the states in the country are now allow this use, and it's pretty much across all kind of political spectrums, if you will, from states like Oklahoma and Alabama that allow it to the states where you'd certainly expect it, like California and New York. So then moving on to the next slide, what's kind of the trailing indicator, if you will, as attitudes and beliefs about marijuana use are changing, that we're seeing also ever expanding number of states that allow recreational use of marijuana. And I know, having given presentations like this, at least for the last decade, this used to be a much shorter list. As I said, talking in the last slide, you can see New Mexico just legalized it just less than 2 weeks ago. Same thing with Virginia. I mentioned earlier, Illinois, it's been about, I think, a year and a half, 2 years now since it's been legal here. So we certainly expect this list to continue growing. And when you look at the states that do currently allow it, it's a lot of the larger states: California, Illinois, Michigan, New York, New Jersey, Oregon, Virginia. So significant percentage of the population have workforces allow or are in states that allow the recreational use of marijuana. So what does that mean? When those states pass these laws, then a number of states also, I think here in Illinois, we certainly saw this, and whatever the reason that the state may change its law, I think here in Illinois, I suspect a large part of that was in terms of revenue and capturing the taxes that would go with the legal sale of recreational cannabis and marijuana. But whatever the reason, in order to make that a fulsome right, one that employees can actually take advantage of, what we're seeing then is a number of states that pass laws that protect the people that are either using marijuana for medicinal reasons. As we see on this slide, a number of states that have amended their state fair employment laws to include anti-discrimination provisions for prohibiting discrimination against people who use medicinal marijuana, which obviously logically follows. So if you have a condition, you have your card, you're prescribed marijuana by your healthcare provider. The state here in Illinois, for example, there are protections that prevent or limit the right or the ability of an employer to take action against that employee. In most cases, obviously, it's not an absolute protection. Doesn't mean you need to allow people to use marijuana who are in safety sensitive positions. As I said earlier, these laws do not trump things like the DOT regulations, but it's certainly, if you get to the point where you are considering discipline against an employee who is using medical marijuana, you certainly need to make sure that you check the laws in your state to see whether there are any protections that are afforded those individuals. And as Ashley talked about, because, and I mentioned as well at the beginning, marijuana at least being a Schedule I substance under federal law, the current use of marijuana is not going to result in a claim, or at least a claim that can proceed under the Americans with Disabilities Act. And I did want to mention, shifting gears just for a brief second, Ashley also talked about prescription drugs. One thing I see a lot when I review employee handbooks are policies that require or suggest that employees need to proactively notify or disclose to the employer any prescription medications that they are using. That is a problem under federal law. That's certainly something the EEOC would take issue with. So if you have a policy like that in your handbook, I would suggest that you take a look at that and talk to one of us or whomever you seek such advice from to determine, if that policy should remain in there, or if it should, how it may need to be revised or reformulated in some form or fashion. So then the question is, with all these laws that are out there, with the limitations, with the protections, so whether your state allows medical marijuana or recreational, can you terminate or discipline or terminate an employee who tests positive for marijuana? So obviously, as you probably can gather from what we've been talking about, the answer is largely going to depend on the state in which you are located. It's going to depend on the nature of the work or the position that employees hold. Is it a safety sensitive position? Again, is it covered by DOT regulations? Does your state have protections for medical use? Here in Illinois, there are even protections or as far as recreational use. So there's a lot that goes into it, and I think those of you that have been tracking these issues and are staying up on the law, this. But again, this is an area where I think, in particular, training management operations people to understand. I think certainly there are a lot of folks out there that just assume drug use, termination. And that's not always going to be that cut and dried. And so you want to make sure the folks that make those decisions can at least issue spot and say, kind of, hit the pause button and say, all right, this may not be as cut and dried as I believe it is, or I suspect that it might have been. So let me pass this on. Let me loop in human resources or legal or whomever, so we can make sure we really consider all the issues. Are there OSHA implications? Are there labor implications? What's the state law here? So that to me, I think, is the most important consideration. Once you hit that pause button, you can take time to gather the intelligence that you need to talk to counsel and really make sure that you're making a decision that complies both with federal as well as state law. So then another consideration and what we're seeing both in states that have passed laws or amended their laws specifically because of the changes in their marijuana laws, or just there are states out there that have laws that deal with the protection of an employee's right to engage in what's called lawful off-duty conduct. In some instances, the background of those laws, it's an interesting history. For example, I think the cigarette lobby many years ago was kind of pushing a number of these laws because it used to be that there would be some employers that didn't want to employ people who smoked cigarettes. There are also these laws that also have evolved over the years due to things like free speech, being involved in demonstrations or things like that. The upshot is that there may be laws in your state that protect an individual who is engaging in conduct while not at work, so they're off duty, that is legal or lawful, and that employers may have restrictions placed on them from terminating somebody because of something they do that is off duty but legal. This obviously can touch on issues like social media, but also can touch on things like drug use or at least the use of marijuana. If you're in a state that it's legal and that your state has a law that limits or prevents terminating someone because of lawful off-duty conduct, then that's another consideration that you need to be aware of. So then moving to I think the last slide that I'm going to cover, which talks about zero tolerance policies. This is obviously a concept that we see not only and certainly not exclusively in the area of drug testing, but also in the EEO world as far as harassment and those types of policies. And I think as zero tolerance policies and their use has evolved over the years, I guess the way I kind of come down on it is it's a more nuanced approach than simply saying, if you violate this policy or this rule, that you're terminated. and you need to be mindful if you're using language like zero tolerance, how you use it and what sort of message you're intending to convey. So I like to starting out actually at the bottom, I think it's important to understand that in no way, shape, or form am I aware of any state or federal laws that would require you to excuse an employee who is either using drugs at work, who is certainly or selling drugs at work, or who is impaired while at work. So whether that's the legal use of medicinal marijuana, the legal use of recreational marijuana, we haven't gotten to that point. I don't think that we ever will. Certainly, if it's recreational use, I think that it's a very clear and simple determination. If the person is even if you're in a state that allows recreational use of marijuana, if the person is impaired while working, that you can absolutely terminate that employee, provided you're doing it consistent with how you've treated other employees who have violated the same or a similar rule. If it's medical marijuana, and perhaps the impairment, they used it at home in a way that they presumed it would not impair them while at work, but it turned out that they are. I think I'd probably counsel a little bit more of a kind of approach that will consider whether there's a way to change, whether an accommodation that can be provided so the person can still continue working and continue using their medical marijuana. If there is no way to do that, no way that based on their dosing or their treatment plan that they can't use it without being impaired, I think in almost every instance you would be permitted to terminate that employee. But I would certainly discourage anyone from making that sort of determination without kind of going through that interactive process, having a discussion with the employee and trying to look for a solution. And so ultimately, what you decide to do with respect to if you say, well, we want to adopt a zero tolerance policy, is determine, what does that mean? What is that going to look like? It could mean that we're not going to tolerate violations of the policy, but the way that violations are handled obviously is going to vary and depend on the circumstances. And you need to keep in mind, I think, from practical standpoint, what is having such a policy going to do to your workforce? Are you going to lose people that you might not otherwise lose, who are not impaired at work, who are not violating your policies because they're concerned about it? Are you going to have trouble hiring people, recruiting people? Certainly in today's economy, where I think many employers are already finding it difficult to fill certain positions, is this going to complicate that further? Do you really need the policy? Perhaps you can tailor it so it's limited to certain positions. Again, we talk a lot about safety sensitive positions. I think if someone's applying to do work around heavy equipment, working on a metal lathe or with power presses or forklifts, I think they would expect and anticipate that they're not going to be allowed to work if they're failing drug tests. But perhaps there are other positions where it's not an issue. So all lots of layers involved. Hopefully that gives you some things to think about, and how you want to communicate that internally. And again, at the risk of sounding like a broken record, really important to make sure that whatever policy or approach you settle upon, that your managers are fully trained so they understand it, so they can communicate it to your workforce, and they can implement it and enforce it in a compliant manner.
Now we're going to start on the second half of the presentation, which is not going to be as long as the first here. I can promise you that. We're going to go through background checks and issues to look out for, and specifically the Fair Credit Reporting Act requirements and how that applies when you are conducting a background check. So just beginning really quick, what is the purpose and scope of a background checks? Well, you're using them to obtain information about potential hires, right? And those checks generally involve determining whether an applicant can be disqualified for a position for some particular reason, be it a criminal conviction, a motor vehicle violation if you're hiring a driver, for instance, poor credit history for those positions where someone's handling money, perhaps, or misrepresentation regarding education, work history. There's a number of different things that may disqualify them from that position. And there's a variety of different concerns that employers have for performing these background checks, right? It could be safety issues, potential legal exposure and risk that you're balancing, and just simply verifying information that's provided by an applicant to ensure that the person that you're hiring is who they say they are, right? So when does the Fair Credit Reporting Act apply? It generally applies when you as an employer are obtaining a consumer report or an investigative consumer report for employment purposes. And it's going to be prepared by a consumer reporting agency at your request. So that third-party consumer reporting agency, typically some vendor that you're working with, and they have a lot of these policies and systems in place already to do that background check for you. There's a lot of steps that you need to take prior to then to make sure that you're doing it in compliance with the law, right? So as you see on the screen here, we have the definitions of what a consumer report is and what an investigative consumer report is. Basically, they're background checks, and there's just minor nuances between the two of them. An investigative consumer report is a consumer report, but with the added elements of interviews and personal touch, interviews with neighbors, friends of the subject, evaluating their character, reputation, and history. So now we're going to get into those critical steps for compliance. And this is just a broad overview of what you as an employer need to be looking at and checking the boxes when you're conducting a background check for a prospective employee or even a current employee, right? So there's the pre-inquiry stage, and that's where we go through the disclosure and authorization forms and providing that applicant or the employee with a summary of rights forms. The certification to the consumer reporting agency, and we're going to cover each one of these elements in a bit more detail, but that certification to the CRA is that you're going to use this background check for a lawful employment purpose, right? And that's fairly standard. You have to do this every time that you're running a back check as this. And the third-party vendor, that CRA that you're working with, is going to request that because it's partly their obligation as well to make sure that they get that certification. And then if you finally get that background check and you are considering taking adverse action, you're not going to hire the person because of things that have been discovered in their background check. There's the post-inquiry stage here, and that's where you will likely have to provide a pre-adverse action notice letter to the prospective employee. And if you ultimately decide to not go forward with that applicant, you will submit to them the final adverse action notice letter. So the risks of running afoul of the FCRA requirements are somewhat high. There's a lot of active litigation out there about what is and isn't required, and it's really a fodder for class actions. We've seen a ton of these over the past decade. And the fines, it doesn't seem a lot that you see on the screen here, $100 to $1,000 per instance. But as you can imagine, if a class action comes up and you're a nationwide employer and you've been violating the FCRA for a couple of years, the number there that you see on the screen, that 100 to 1,000, could multiply by 10,000, say. And you're looking at potentially millions and millions of dollars in fines or damages, I should say. So let's go through those elements one by one. The disclosure form here, that's the first step. If you're running a background check on a prospective employee or a current employee, you can't run that background check unless you give them the disclosure form. And of course, you're going to obtain the authorization from them as well to conduct that background check. But what needs to be on that disclosure form? Really, we want it to be as simple as possible. All you need is a clear and conspicuous disclosure in a document that says that a consumer report is going to be obtained for employment purposes. It doesn't need to be fancy, and where employers really get tripped up here is including it in some other form of your application, right? So here's the key practice notes that we suggest really honing in on, and these are some of the common mistakes that we see. So make sure that that disclosure form is on a standalone document. It can't be embedded in an application. It can't be at the bottom of a page, which just, you know, 1 or 2 sentences. It needs to be its own page, one single page. You want to define what the consumer report and investigative consumer report are and indicate what it's being used for. So again, identifying that this consumer report or in this investigative consumer report is being obtained for employment purposes to evaluate your employment, your application for employment. And then for investigative consumer reports, you want to make sure that you have a statement of the individual's right to request additional disclosures regarding the nature and scope of the report itself. So these are all nuances in the Fcra that a lot of employers miss or forget about, but it's something that class action plaintiffs' attorneys pick up on and multiply quickly. So that standalone disclosure requirement, just tying in some recent case law that we've seen. This was out of the Ninth Circuit in 2017, one of the seminal cases kind of addressing this issue. And there, the Ninth Circuit ruled that a prospective employer violated the Fcra when it procured a job applicant's consumer report after including a liability waiver in the same document of the Fcra disclosure form, because they ruled that it was not a document that consisted solely of the disclosure. So again, just the bare minimum of what we had on that prior screen should be in your disclosure form. Don't embed it in an application. Don't include any other extraneous information in that disclosure form at all. So this kind of runs through some of the things that we've just been talking about, those key practice notes. Don't include the disclosure in a job application. Don't include any liability waiver or release of claims as it relates to those or any other claims in the disclosure form. Don't require an applicant to certify the accuracy of their application. If you want to do that, do it on the application itself, not the disclosure form. Keep it simple. Avoid the legal jargon. It really needs to boil down to 2 to 3 sentences. Next here, don't include any extra acknowledgments and avoid any broad authorizations that permit the release of information that the Fcra doesn't contemplate or doesn't allow to be included in a background report itself. So alongside that disclosure form, you also need to obtain the authorization from the employee. So the compliant form for authorization purposes is just an acknowledgement that a pre-employment background check will be conducted on that applicant or the employee. So again, keep it simple. You can provide that authorization on the disclosure form itself, but best practice is to keep them separate. It's easy to combine things and make sure it's just one page, and it may be easier administratively. But this is an area of law that is picking up traction with plaintiffs' attorneys, and best practice, just keep the authorization form separate from the disclosure form. Alongside that disclosure form and the authorization form that you're providing to the employee, and this is all prior to running the background check, right? You're going to be providing them a copy of the consumer rights form under the Fcra. And this is issued and available online by the Consumer Financial Protection Bureau. There's a link right in their website. You download it. That should be provided simultaneously with that authorization form and that disclosure form. And our best practice and advice is also obtaining an acknowledgement separate from that disclosure form and that authorization form that says they received this form as well. So the certification piece, we talked about this a little bit, and this is fairly simple. Employers need to certify to the consumer reporting agency, so that third-party vendor that's performing the background check for you, that it's being used for a permissible purpose. And what you see on the screen here is what should be included. And that is essentially that you're complying with the Fcra, that you've provided the disclosure to the applicant, you've obtained authorization, and that you're going to comply with all the Fcra requirements before taking any adverse action. So those pre-adverse and adverse action notice requirements that we're going to get into in the next slides here. And moving on now to that piece is before you reject a job applicant, you're terminating an employee based on what is in that background check. You need to provide written notice that includes a copy of the report itself and provide a summary of rights form again. So a couple different elements that you're providing there, but the letter, the notice letter, really just needs to inform the applicant that they are that the company, that you as the employer are considering taking an adverse action based on the contents of what was provided in the background check report. And it provides them an opportunity to review it and tell you if there's anything that's incorrect, or provide some type of explanation for why something is there. And there's usually a certain period of time that provide employees to contest what's in their background check report prior to issuing them final adverse action letter. So if you've provided that pre-adverse action letter, you've gone through the period of time in which employees can contest and address whatever was in that report, and you're still going forward with taking an adverse action, you need to provide a final adverse action letter. And what that needs to include is a statement that adverse action is being taken based in whole or in part on the consumer report received from that third-party vendor. You're going to provide the name, address, telephone number of that consumer reporting agency, and a statement that the CRA that supplied the background check report didn't make the decision to take the adverse action and can't provide specific reasons for that decision that you as an employer are making. And then there's also that final notice of the employee or the applicant's right to dispute the accuracy or completeness of any information the consumer reporting agency furnished, and that must be done within 60 days. I'm going to turn it over to Ashley, and she's going to go over quickly the state and local restrictions on background checks, and then we should wrap up from there.
Thanks, Dan. So just looking at the state law implications of this, some state and even local laws impose additional requirements to those just discussed by Dan, as well as limitations on employers when conducting background checks. For example, in New York, when the timing requirement is different, so whereas the federal law permits notice to be given as late as 3 days after a request for an investigative consumer report is made, so long as the employer had already obtained the individual's consent before reaching out for that investigative report, the New York law requires that the employer notify the individual that it will request an investigative consumer report before making that request. So in New York, you have to actually get the consent of the individual as well as provide notice prior to collecting the investigative report. Additionally, as it relates to the notice requirement, unlike the federal law, the New York law requires employers to notify applicants or employees that it will obtain a consumer report and advise them of their additional rights to know if the employer requested a consumer report by making a written request for that information, as well as to inspect or order a copy of the consumer report from the consumer reporting agency. Another state-specific limitation is the look-back period for criminal background checks. States like New York, Maryland, Massachusetts, and the city of San Francisco have limited that look-back period to 7 years. And additionally, some states have limited the types of inquiries that employers may make. For example, again, in New York, an employer generally cannot inquire about previous arrests or accusations if they're not still pending and they did not result in a conviction or a guilty plea. Employers in New York cannot ask about youthful offender adjudications, and also they're prohibited from asking about sealed conviction records. Next, we'll talk about some statewide ban-the-box laws. Employers should also be aware of state and local jurisdictions that have implemented the ban-the-box laws, and these laws prohibit employers from inquiring into a prospective employee's criminal background on its application or during the early stages of application review. So states like California, Illinois, and Maryland have these laws, and then also localities like Buffalo, New York City, Rochester, New York, they also have these ban-the-box laws. And so employers should be aware of what the jurisdiction requirements are in their state as well as their city, and be aware that if they are in a locality that has banned the box, it is unlawful to inquire or consider that applicant's criminal history before, so importantly, before the employer has made a conditional offer of employment. And so this covers all things that happen before that conditional offer, including on-job applications, in-job interviews, or any sort of verbal inquiries that happen before the conditional offer of employment. And several states have also added additional consumer protection laws that require employers to provide notices or additional procedural safeguards to employees, such as those that we just discussed in New York. So employers need to look closely again at the laws of their local jurisdictions, as those often impose additional requirements. For example, employers in Prince George's County, Maryland, need to list the items that are the basis for prospective adverse action if it is based on a criminal record and the pre-adverse action notice letter that Dan mentioned earlier. And they are also required to delay rescinding an offer of employment for 7 days to permit the applicant to give notice of any inaccuracies. Employers in Illinois now have similar requirements. Earlier this year, the governor signed the Employee Background Fairness Act, and that law amends the Illinois Human Rights Act to make it a civil rights violation for employers to use an individual's criminal conviction record and an employment decision unless there's a substantial relationship between the offense and the individual's employment. And so in Illinois, the employer has to notify the affected individual that the criminal conviction is the basis for disqualification, provide the employee with a copy of the criminal history report, and then give that applicant up to 5 days to submit information to convince the employer not to take an adverse action. And then finally, we'll close out our discussion today with other legal issues related to background checks. And so as we've mentioned in passing throughout our presentation, drug testing and background check laws are invaluable because they help employers ensure that their workplace is safe from known hazards, including employees who are not qualified to perform the job. And here we have a couple of demonstrative cases of that. In Reagan, a timber company was held liable for $7 million after a truck driver caused an accident resulting in a fatality. And so the timber truck company driver lied on his application that he had a clean driving record. And in fact, that truck driver had received 2 license revocations as well as other previous infractions. And the court held in this situation that in spite of the misrepresentations that the truck driver made on his employment application, the timber company could have easily discovered those misrepresentations with a simple background check. And similarly, in Denton, a trucking company was held liable for $54 million under theories of negligent hiring and retention after a trucking accident. And so here, the driver again lied on his resume and application about his driving record. The driver, in fact, had several driving infractions and convictions for vehicular assault and had been terminated by 4 of his 7 previous employers over a 10-year period. And the court found here again that the employer's failure to look into this driver's background beyond what he put on his resume and his application were insufficient because these misrepresentations could have been discovered with a simple background search. And so while we understand the importance of doing these background checks, employers must ensure that in doing these checks, they're complying with all state, federal, and local laws such that there are no disparate impacts. And so a disparate impact occurs when a policy or practice appears to be neutral on its face, but results in a disproportionate impact on a protected group. And so employers should ensure that their background check and drug testing policies do not result in the disparate treatment of employees and prospective employees in a protected category. For example, employers should not treat similarly situated applicants with criminal records differently based solely upon their race, national origin, sex, or other legally protected characteristics. And I know Aaron mentioned also, as we think about the ADA and drug testing and those who, for some reason, require a reasonable accommodation to have that drug testing, employers should also think through that as well. And we are going to close out our presentation with some EEOC best practices. And so as you can see on the screen, the EEOC has provided best practices. The EEOC's enforcement guidance on the consideration of arrest and conviction records from 2012 just gives general best practices for using background checks, the implementation of a background check policy, and likewise any information of how information obtained in a background check can be used while not being discriminatory. And last but certainly not least, the employer should, to make sure they're not running afoul of any of the discrimination laws or EEOC's best practices, the employer should conduct an individual assessment of each applicant. And what that means is a criminal conviction should not de facto exclude an applicant, from consideration. And so some of those factors should be the job duties and the employee's responsibility, the type and number of crimes, the time elapsed since the crimes, if the employee or prospective employee has been able to show in some way that they've been rehabilitated, and any subsequent employment and training experience that that applicant or employee may have. And finally, if not already required by state law, employers may consider allowing an applicant to provide additional information or an explanation for their background or drug test results. And with that, I think I turn it over to Aaron to close us out.
Thanks, Ashley. We hope that you all found this interesting. As Ashley said, this will conclude our program. If you are not signed up for all our webinars, we encourage you to do so. As I think you all likely know, we host webinars every month, and we always enjoy chatting with folks. If you have any questions about anything that we covered today that you didn't have a chance to submit live during the program, we're happy to answer that if you want to reach out to us either by email or by phone. And if you're listening to this over the recording and obviously didn't have a chance to ask your questions, then please don't hesitate to do so once you've heard the recording. As we all have said throughout the program, we're happy to discuss any of these issues. I know there are a lot of things that we've talked about with respect to policy reviews and training. So we're happy to help in any way we can. So with that, that'll conclude our program today. Thanks again for joining us, and we look forward to talking with you all again in a future program. Thank you.